This is our first Breakfast Club of 2021 and our fifth since we've started hosting them virtually. And my name is Tom Fairhurst. I'm Marketing Executive at Kuits and I'll be your host for the next hour. For those of you joining us for the first time or unfamiliar with Kuits, Kuits is an award-winning commercial law firm operating out of Manchester City Centre. And one of our key specialisms is providing expert guidance for employers and HR professionals. For those of you who have attended one of our HR breakfasts before, welcome back. We hope everybody finds today's session informative and engaging, and the agenda for which I'll take you through shortly. So just on to the speakers for today's webinar. I'm delighted to introduce our speakers from the Kuits employment team. So today we welcome Sallybird, who's a partner, and Treacy, who's a solicitor. Sally's going to present our HR hotspot this quarter. She's going to be considering no job policies as we come out of the latest lockdown and their potential impact and risks. And Claire's going to provide you with some insights on recent case law updates that we think will be of interest. And today we have our guest speaker, which is Ali, who is Technical Director of Hexegic. Hexegic are a consultancy providing cybersecurity services to UK SMEs. Ali's going to speak to you a bit about insider threats and hazards when it comes to cybersecurity and how you might be able to mitigate them within your businesses. I'll just quickly take you through the agenda for today. So shortly, I'm just going to take you through some ways to connect with Kuits and a little bit of housekeeping. Claire's then going to give her case law update. We'll then come to Sally for the HR hotspot, and then finally we'll finish off with Ali with his guest speaker slot. So just some ways to connect with us moving forward after this webinar. So if there's anything you'd like to engage with us on or have a conversation, here's just some additional contact details for you. So Kuits phone number, email address and website. Just to flag on the Kuits website, if you go to the insights section, we have a number of legal updates and expert insight pieces that we update on a regular basis, not just from the Kuits employment team, but from across the firm as well. And also on the Kuits website, if you can join our mailing list, if you're not already a part of it. And then just to talk quickly about the Kuits social media presence as well. So we have a Twitter account, LinkedIn account, and YouTube. If you use any of those platforms, please follow us. Hopefully you will find some engaging content on all three. And just to flag that we are recording this webinar and it will go out on YouTube later on today or tomorrow. Also to say that the 4 previous HR breakfast webinars we've done are on the Kuits YouTube channel, including the last one that was on managing mental health in the workplace. So you can go to the Kuits YouTube channel and find those videos. And then just some final housekeeping before we get into the main bulk of the webinar. Just to say in terms of questions today, so the agenda we've got is quite tight. If you have got any questions, please submit them through the Q&A box. And if you could leave your name when you submit that question, we would really appreciate that. Just in case we don't have time at the end to get to those questions, we will follow up with you after the webinar. And if we do get some time at the end, we will invite some questions as well, and hopefully be able to give you some answers. And then also just to say there will be a follow-up email on the back of this webinar as well. That email will contain the contact details of the speakers, a link to a feedback survey, and also a link again to sign up to our mailing list if you haven't already. And then the recording of this webinar will be shared separately to that as well, and will be emailed across to you. So again, if you've got any friends or colleagues who you think might find this content useful, please feel free to pass it on to them. And that's all from me for now. So I hope you enjoyed today's session. I'm going to hand over to Claire, who's going to give you our quarterly case law update.
Yeah, thanks, Tom. So the first case I'm going to talk about is the case of LA UK Limited against Galen, and this was a case that was determined in the Employment Appeals Tribunal, and it focuses on the defence that employers can have to discrimination claims. So the claimant, Mr. Galen, he had been dismissed for reason of poor performance. However, following his dismissal, he complained that he had been subject to racial harassment by one of his colleagues. Now, these complaints were investigated by the respondent, but nevertheless, the claimant submitted a harassment claim, a racial harassment claim, I should say, and an unfair dismissal claim in the tribunal. The tribunal accepted that the reason for his dismissal was poor performance and therefore that he had not been unfairly dismissed. However, it found that Mr. Galen had been subject to racial harassment due to the racist remarks that one of his colleagues had made to him on several occasions. So when defending this claim in the tribunal, the respondent company tried to rely on what is referred to as the reasonable steps defence. So this defence allows employers to defend discrimination claims where they are able to show that they have taken all reasonable steps to prevent the employee perpetrator from committing the discriminatory act complained of. So here, the respondent said that they had taken all reasonable steps to prevent the perpetrator from making the racist remarks. And they argued this on the basis of two things. So first of all, that they had an equal opportunities policy in place and a anti-bullying and harassment procedure. And that also importantly, both the claimant and the alleged perpetrator had received equal opportunities training and bullying and harassment training. So when the tribunal looked into this, they decided though that they were going to reject the respondent's defence. And the reason for this was because the training had been carried out back in 2015 and the policies had last been updated in 2016, so quite some time ago. The tribunal therefore concluded that the training was clearly stale and no longer effective to prevent harassment, and that there were further reasonable steps by way of refresher training that the respondent could have done. So although the initial training at the time had been adequate, it was then deemed stale 2 years later. And this was evidenced by the fact that the harassment occurred several times and that Mr. Galen's managers were aware of the racist comments, but had done nothing to prevent them. They hadn't, for example, reported the matter to HR and they hadn't taken disciplinary action against the perpetrator. So the appeals tribunal even went so far as to say that the brief and superficial training was unlikely to have a substantial effect on preventing harassment. Instead, what is needed is thorough and forcefully presented training to make it effective and to prevent harassment in the workplace. And it was also noted by the appeals tribunal that the respondent's equal opportunities policy did not make any reference to harassment, and their anti-bullying and harassment procedure only referred to harassment in the title. Thereafter, it only referred to bullying and made no mention of harassment. So the appeals tribunal said that this policy wasn't adequate to prevent racial harassment in the respondent's workplace. So this case is really useful to show that in order to be able to rely on this defence, employers need to review their policies to ensure they are adequate and that they're up to date. And they also need to provide thorough and well-presented training to their employees at least every 2 years. And if they've done those things, then it seems that a tribunal will consider this defence. So if we just move on to the next case, which is a case that was heard quite recently actually in the tribunal. So it's not actually a case that is binding on other tribunals, and it could well be appealed to the appeals tribunal, this one. But it is relevant because of all of the COVID secure measures that employers have had to put in place to some extent during the pandemic. So in this case, the claimant was a delivery driver for Kent Foods, and most of his work involved travelling to and from the site of one of Kent Foods' customers. And in May 2020, due to the pandemic, the customer required all individuals visiting their site to wear a face mask, which was issued to them on arrival. So this applied to the claimant, even when he was in the cab of his truck, on the basis that droplets could fall from his mouth onto others when the window was open because of his elevated position in his cab. So the claimant, though, refused to wear a face mask on a number of occasions, stating that the cab was his private place and that it wasn't the law to wear a face mask when he was in it. The customer, therefore, obviously reported the claimant to Kent Foods and banned the claimant from their site. So the claimant was invited to a disciplinary hearing by Kent Foods on the basis of an allegation that in refusing to comply with the customer's instructions regarding PPE, he had breached the requirements to maintain good relationships with customers and to cooperate to ensure a safe working environment. And this was because, in particular, Kent Foods employee handbook required courteous behaviour towards customers, including adhering to customer instructions on the use of PPE and taking all reasonable steps to safeguard their own health and safety at work. In particular, their driver's handbook required customer instructions regarding PPE to be followed. So the consequence of this disciplinary procedure was that the claimant was dismissed for gross misconduct. This then prompted the claimant to go to the tribunal with a claim of unfair dismissal. When the tribunal delivered their decision, they said that the claimant had not been unfairly dismissed, and that was because the decision to dismiss was reasonable in the circumstances. And the tribunal gave particular attention to the fact that Kent Foods had been entitled to take into account the importance of maintaining good relationships with their customers. Also, the fact that the claimant throughout the disciplinary procedure had continued to deny that he had done anything wrong. Obviously, this was concerning to Kent Foods. And then also the practical difficulties as Kent Foods were unable to deploy him to another area in their business, bearing in mind that he'd been banned from this particular customer's site. So whilst this is only a tribunal decision, as I said, the case does show that a tribunal will place importance on the impact of an employee's conduct on an employer's relationship with its customers when deciding if a dismissal is fair. However, though, this case should not be used to presume that if an employee refuses to wear PPE, then that will amount to gross misconduct. That's because there might be a whole host of reasons that employees don't want to wear PPE, whether that's for disability reasons, they've got a medical condition that prevents them from wearing a face mask perhaps, or because of any beliefs. And in these, because of these risks rather, each situation needs to be considered because there are risks of discrimination claims if employers do use this case as a blanket reason to be able to dismiss employees in this situation. So we move on to the final case that I'll talk about, which is the Uber case, which you all probably heard about because that was reported quite widely last month when the Supreme Court delivered their decision about the fact that they deemed Uber drivers to be workers as opposed to independent contractors. So the 35 Uber drivers had first actually challenged this or their employment status in 2016, and they'd argued that they work under workers' contracts and should therefore qualify for workers' rights, such as the entitlement to the national minimum wage and to paid holiday. Whereas Uber had argued that the drivers do not have workers' rights because they work for themselves as independent contractors. And this was argued on the basis that the drivers provide services under contracts and made directly with passengers, and that Uber are merely their booking agent. However, the Supreme Court agreed with the drivers, and they agreed this on the basis of a number of factors which they believe demonstrated an element of control that Uber had over their drivers. So some of these elements were the fact that the drivers' wages are fixed by Uber, and this is because Uber decide the fare and how much pay per ride the drivers receive. Uber dictate the contractual terms on which drivers have to perform services. For example, the drivers are not able to dictate their own terms with each passenger. A driver's choice about whether to accept rides is controlled. For example, Uber do not reveal the passenger's destination to the driver until the passenger is picked up, by which time the driver cannot decline a trip if they do not want to travel to that destination. Similarly, the driver's rate of acceptance and cancellation is monitored. So if a driver cancels too many trips, Uber can log them off the app for 10 minutes so that they can't work. So due to these factors, the Supreme Court rather found that Uber exercises a significant degree of control over its drivers, which established that of a worker status rather than an independent contractor status. And when they made the decision, the Supreme Court made it really clear that the starting point was not to look at what it said in the written agreement, because in the written agreement between Uber and its drivers, it did clearly say it was a relationship of an independent contractor. But the Supreme Court said when you looked at all the factors of control that Uber had over its drivers, this was simply irrelevant. In fact, what is said in the agreement should be the very last factor that is looked at. The Supreme Court even went so far as to say that any clause in a contract which indirectly or directly stops an individual from having rights in an employment tribunal on the basis that they don't have employment status as an employee or a worker will be unenforceable. Instead, the Supreme Court made it clear that courts should look at the reality and the characteristics of the working relationship to determine the correct employment status. It's really important, therefore, that any written agreement actually reflects rather what happens in practice. So the crux here for businesses to understand is that they cannot have the benefit of having control over individuals, as well as having the benefits of engaging those individuals on an independent contract basis. If a business wants control over individuals that work for it, for example, to be able to dictate when they work and where they work, and for them to be in an insubordinate relationship with the business, then they must accept that these individuals will have at least worker status and therefore the right to aspects such as national minimum wage, sick pay, and holiday pay. So since the decision last month, Uber have already come out to say that they will reclassify 70,000 of their drivers as workers. And obviously this will have increased costs for Uber. So we'll see whether that cost is passed on to us or it's absorbed in the business. But it's come at a really timely, paramount time, this case, because of the IR35 rules, which are now going to be coming into force next month. And these were the rules that were delayed from being passed through into legislation last April because of the pandemic. And the new IR35 rules mean that the business, rather than the independent contractor, will be responsible for determining the correct employment status and ensuring payment of the correct tax is made. And therefore, if businesses get this wrong, it will be them that gets the penalty from HMRC rather than the independent contractor. That's everything for me on the case update. So I was going to pass over to Sally now, who is going to do the HR hotspot on the no job policy.
Thank you, Claire, and good morning, everybody. So I have something of a hot topic to talk about today, which is no jab, no job policies. And the question we'll be looking at is whether an employer can impose a no jab, no job policy. And the simple answer is it depends. The classic lawyer's answer. So it's been in the news. The chairman of Pimlico Plumbers hit the headlines because he announced that he intends to require all new recruits to have had the vaccine, and going a step further, that he intends to change the company's contracts to make it a contractual requirement for their current employees also to have had the vaccine. Earlier this week, the trade union, the TUC, conducted a poll of 1,000 private sector employers, not public sector. This found that 1 in 7 had already introduced a no jab, no job policy. So these things are being introduced. Interestingly, that same survey found that less than half of that group were willing to give staff paid time off in order to take a vaccine. That is an obvious barrier to encouraging your workforce to be immunised. And in my opinion, that would undoubtedly be considered to be unreasonable alongside running a no jab, no job policy. Now, the government has no plans to compel any person to take the vaccine. So employers will not be able to enforce this on the basis of an underlying legal obligation. That doesn't mean, however, that an employer would not be able to enforce a policy simply because there isn't an underlying law. Now, anti-vaxxers, many people might regard anti-vaxxers as being somewhat selfish individuals who are being unreasonable in failing to act for the greater good. But there are many reasons why workers may choose not to take a vaccine. So that could include medical advice, their religion, their philosophical beliefs. They may be pregnant. They may have a disability, or they may just want to retain autonomy over their medical choices. Many people would also wish to wait for more evidence that vaccines are safe. Now, whilst we have clear evidence emerging that vaccines have significant benefits in terms of preventing severe implications from the disease and hospitalisation, there is more uncertainty about the extent to which vaccines prevent transmission of the virus. And this, I think, would be the key piece of evidence for employers to justify the imposition of a policy requiring employees to be vaccinated. If they could say, well, no, the medical evidence shows that this will prevent transmission and therefore make workplaces much safer. Now, the employer is in a difficult position because it has criminal and civil duties to maintain a safe workplace under health and safety legislation. And employment law and health and safety often don't sit comfortably together, and there's no exception here. The key question is always around reasonableness and proportionality, which is a lawyer's dream, but an employer's nightmare. It's a balancing act, but in my view, there's a basic principle that if an employer can show that the risks of infecting others outweighs the contravention of somebody having freedom of choice on their vaccination, then the employer may be able to justify introducing a policy. Now, looking at the contractual position, there's a distinction to be made between new staff and existing staff. You can obviously impose on new staff who we haven't yet recruited a requirement to have a vaccine in order to be recruited. And that could take the form of it being a condition of employment, much in the same way as you might say a satisfactory reference is a condition of employment. For existing employees, it's very unlikely that there will be any form of express clause in a contract that would permit you to force somebody to have a vaccine. The closest we come to seeing that is an express obligation to require an employee to submit to a medical report, for example. So there's very unlikely to be anything express in the contract. So an employer could consider, as Pimlico are doing, changing the contract in order to include an obligation to have a vaccine. But of course, you can't change a contract without an employee's agreement. And if an employee doesn't agree, then you have to consider going down the route of imposing it through terminating the contract and re-engaging the individual on new terms. Now, in appropriate circumstances, my view is that you wouldn't need to go that far. If you can show that the requirement to have a vaccine is a reasonable instruction, or alternatively, you might say, well, there is an implied term to make this contract work, to give it business efficacy, that you have a vaccine in order to be able to do your job safely. So if we can look at the risks that might arise from introducing a no job policy. So firstly, unfair dismissal claims. So we all know that an employee would have to have 2 years service in order to bring a claim. but that could be a straight unfair dismissal claim if they were ultimately dismissed for refusing to have the vaccine, or it could be a constructive dismissal claim if they resign on the basis of being forced to have the vaccine. Now, this of course begs the question how in practice an employer might deal with an employee who refused to be vaccinated. So if the employee had a legitimate medical reason for rejecting a vaccine and they had a doctor's letter to that effect, then it may be that that employee would need to be suspended on medical grounds. Now that comes with a cost because they would be entitled to be paid for up to 26 weeks. If the employee's reasons were not perceived to be legitimate or reasonable, and the sense was that they were jumping on a bandwagon, that could be regarded as a disciplinary matter if the position was taken that they were failing to follow a reasonable instruction. They would then be subject to suspension. And again, usually where you suspend pending disciplinary action, there is a right to full pay. So again, there's going to be that cost. Now, other options that would need to be considered would be restricting the employee to alternative duties or enabling them to work from home or continue working from home. And in any unfair dismissal case, an employer needs to show that it has considered alternatives to dismissal before reaching that ultimate decision. Now, another potential option might be use of the furlough scheme, which has now been extended until the end of October. And it's still the case that you can place an employee on furlough and you don't have to satisfy any particular reason or test as to why you are doing that. So if it was an unfair dismissal, what would be the potentially fair reasons that an employer may look at? They would be conduct or that catch-all reason, which is some other substantial reason. Those would be the relevant reasons. My apologies, my screen keeps freezing here. So, discrimination claims. An employer would be imposing a requirement. So it would be at risk of claims of indirect discrimination. And those arise where you impose a provision, criteria, or practice on everyone, but it places a particular group of employees at a particular disadvantage who have a protected characteristic. However, it can be justified by the employer. So, disability would be the first protected characteristic. So, those with some disabilities, for example, those undergoing treatment for cancer, may be advised not to have the vaccine because they are immunosuppressed. Pregnancy. So there is still no guarantee that a vaccine will not cause harm to an unborn baby. Conversely, there is no evidence of harm, but pregnant women are likely to be far more risk averse. A big one, age. So if, like Pimlico, you are restricting recruitment of individuals to those who've had the vaccine, well, necessarily, you're only going to be recruiting older employees because the vaccine rollout program is being determined by age. So that's ruling out a whole group of younger people, which would inevitably lead to indirect discrimination on the grounds of age. Religion or philosophical belief. So religion, some religions abstain from vaccinations. That's sometimes due to the use of animal products in their development. And vegans might also reject vaccinations on the same, for the same reason. And you might recall the decision that did hold that vegans can be held to have a philosophical belief and therefore be protected under the Equality Act because that is a protected characteristic. Now, it's understood that the COVID vaccine does not contain any animal produce, incidentally. Now, belief and anti-vaxxers. So a belief has to be genuinely held. It can't just simply be a viewpoint or an opinion based upon what somebody read in the news or the Daily Mail or saw on GMTV. It must concern a weighty and substantial aspect of human life, and it must be worthy of respect in a democratic society. So that, I think, would be a highly debatable area. If somebody was simply acting on the weight of social media or some public opinion, they may struggle to get over the hurdle of showing that that's a philosophical belief. Sex discrimination. So there was a survey carried out in December 2020 of 55,000 people, and that found that the group that were most likely to refuse a vaccine were women in the age bracket 18 to 34. And that was because of a fear of fertility issues. No medical evidence for that, but that is a defined group who are more sceptical. And then we've got our old friend, the European Convention of Human Rights, on human rights. So under Article 8, there's a right to respect for private and family life. Forced medical treatment obviously cuts across that. Interestingly, there is a case that is going before the European courts in July this year concerning an individual in Romania who was actually fined for refusing to have a vaccine. So the legality of that is being tested. And we all hope that that case, once it's heard in July, will give us some clarity and some guidance. So if we move on to the practicalities of having a policy. So it really is necessary to differentiate between the type of sector you are in and the degree of exposure you have to vulnerable people. Clearly those in hospitals, care homes, it might be thought it's going to be far easier to justify having a requirement to have the vaccine than in other office-based jobs. But whilst it's a legitimate aim, it has to be proportionate. So can the same health and safety objectives be achieved through other means? So all businesses will already have an array of COVID-safe measures that they've implemented: social distancing, hygiene, provision of hand sanitizer, temperature checks upon entry. Many employers are looking at the increased use of testing for their employees, because tests are now widely available and are free of charge to obtain. So I know of many businesses who are requiring their employees to carry out a test on a Sunday before they return to work on a Monday each week. So if those measures can promote a safe workplace, it may then be not justifiable to say you have to have a vaccine. Now, I did want to touch on data protection considerations, because a question I've been asked quite a lot is whether it's okay for an employer to keep a kind of register of who's been vaccinated and who hasn't. Now, in doing that, you will be processing private health information about a person, and that's special category data under the GDPR. So you have to have a specific purpose and justification for doing that. You can't do it purely for monitoring reasons. You have to link it to a compelling need to maintain health and safety in the workplace. And another question I was asked was whether an employer would be able to disclose to other employees, even if they were managers, whether a certain individual had been vaccinated or not. And I think great caution would have to be exercised there, because I think that would be a breach of an employee's privacy, a breach of confidentiality. And I could see how that could quite easily give rise to difficulties and even a constructive dismissal claim. So, as I've just touched upon, alternatives to a vaccination policy. So, adopting a soft approach. And this is what the government are seeking to encourage employers to do. So it's to educate and encourage staff that vaccines are safe, that it's in everybody's interest to have one. Certainly, part of this would be the provision of paid time off to have the vaccine, even if an employer's usual policy is that it will not pay staff for routine medical appointments. Consider making an exception due to the importance of this issue. And be transparent and emphasise the pros and the cons and take a balanced approach. But emphasise the benefit to the business as well, and to colleagues of having and maintaining the safest work environment that there can be. So just moving away from the government, from no jab, no job, government guidance. So we now have a roadmap out of lockdown with various COVID rules being relaxed before the 21st of June. The guidance on leaving home to go to work and working from home hasn't changed. It's due to be reviewed in the week before the 21st of June. So the position is still that where possible, employees should work from home. Employees should only go to work if they cannot reasonably work from home. And the guidance really is quite strong in saying employers need to take every possible step to facilitate their employees working from home, including the provision of equipment, etc. So again, it's going to be, that alone will make it difficult to compel employees en masse to return to the office. And simply because pubs are opening outside on the 12th of April or inside, that bears no relation to this issue of the workplace. So the return to the office looks different for every company. There are, city centres that have been like ghost towns. Many will want employees to return. It may be possible and feasible to work from home, but it may go against an ethos of collaboration, exchange of ideas across departments, and it also has an impact on employees' mental health. On flexible working, what is clear is that if home working has been achieved, it may not be the very best means of working, but if it's shown to be workable, I think it's going to be very much more difficult for employers to decline flexible working requests. Some of the reasons that used to be given to refuse an employee being able to work from home would be, well, we're not able to monitor or supervise their work, or we feel that it will impact on productivity. In many cases, I just don't think that's going to wash anymore. So my final two slides are just optional modes of working, which are obvious, going from the extreme of everyone back in the office to everyone working remotely. So some of the suggestions or models that clients are adopting are having everybody in just on one day, so at least everybody gets to interact on that day, or having A and B teams and continuing with that model. Okay, so I'm conscious of time now, so I will hand over to our guest speaker, Ali from Hexegic, who's going to talk to us about employee cyber threat.
Thanks, Ali. Good morning, everyone. Welcome. My name's Ali. I'm the technical director here at the company called Hexegic. And I'd like to take the opportunity this morning to cover what's becoming a rising trend in cybersecurity, and one that is directly relevant to your positions as senior HR staff and business leaders, and that is the insider threat. What makes us qualified to talk about it? Well, I've spent the last 14 years working with UK government and businesses on improving cybersecurity posture, and we've made a whole business out of taking a holistic approach to cybersecurity, which means that we encompass not just technology and process, which is actually relatively easily to do, but also in people. After all, people are your biggest cyber threat, but they're also your first line in defense and potentially your biggest defense. Next slide. So what is the insider threat? Well, typically we consider them in three ways, and it's shown here on the Venn diagram. So we'll go right to left instead of the normal way. Firstly, a non-malicious actor, a non-malicious person, for instance, who creates a hazard by making an accidental error. I think we can all say that we've clicked on a link that we probably shouldn't have, even after training. And although accidents will always happen, we can seek to minimize those sorts of things through fostering open reporting environments and kind of being very open in the workplace. Then on the far left, a malicious actor. This is someone who knowingly acts as a threat against the organization. So typically a disgruntled employee, someone who's colluding with others. And really they're seeking gain or even retribution through their actions. And then we have this slice in the middle, which is really a negligent actor. And it's through negligence, what I mean is someone who doesn't mean to cause a threat to happen, but does inadvertently through things like breaking acceptable use policies. We worked with a company on an incident response where a developer had gone to download what he thought was Spotify because he wanted to listen to music whilst he was coding, and unfortunately didn't download Spotify, downloaded a piece of malware. Because he was on a development network, the malware executed and he took out a large chunk of his company's workforce and work through what was a negligent act, but it had quite a big effect. The key differentiator between these actors is actually motive. Why are we concerned about insider threat? Well, we're seeing an increase in it. The stat on the bottom of the screen says over 60% of cyber threats now involve some sort of insider. Whilst the vast majority of these are accidental or negligent actors, I predict now that in the coming year or two, we'll see an increase in the malicious side, an increase in malicious actors. And I think this is caused primarily by the pandemic and the uncertainty that it creates, which can lead to or be a key personal factor, and I'll talk about that in a minute. The problem with insider threat is the fact that they're on the inside. These people are already within your network. By definition, they have a level of access, and that makes them one step ahead of any external risk. It makes them harder to detect and harder to stop. So the question we need to ask next is, why do these risks exist? Unfortunately, the answer isn't straightforward. Next slide. The most important thing to note is that from various studies, it would appear most perpetrators do not seek to start out as security risks, which then means that it's a combination between individual and organizational factors which lead them onto what we call the critical path to insider threat. Now, on the non-malicious or negligent side of the spectrum, it's often actually the organization or organizational factors that are the root cause of the problem. Organizational factors are things that the business is responsible for, such as working environment. And these are things that HR and business leaders such as yourself can have an impact on. There's such things like security practices. Here we need to consider things like hiring practices, clarity of policies, security training. You'd be surprised, but something so innocuous as a misstep in an interview can actually lead an employee to starting their time with a job with some sort of disgruntlement already. Communication issues, we saw this last year. It was a significant problem because of the pandemic. Whilst management scrambled to work out how to navigate their business through lockdown and beyond, what they lost sight on was how to communicate that all the way down the organizational chart. And that led to significant issues with uncertainty in the workforce. And that can have a huge impact on and be a personal factor, which can then lead to an inside action. Management systems are an organisational factor. Here we're not talking about things like ISO 9001. We actually mean things like distractions, insufficient resource, poor management styles. They can all be contributing factors to lead an individual onto the wrong path. And work planning and control, things like workload, job pressure, task difficulty. All of these are factors that can contribute to someone cutting corners, becoming possibly negligent, and thus a threat. On the malicious side, typically it's individual factors that are more at play. And here we can consider things like boundary violations. So these are concerning work habits, minor policy violations, interpersonal problems. Then we have cyber security violations, so IT related issues such as data transfer patterns, authentication attempts, network patterns. We've got things like job performance, what we call cyber loafing, which is where an individual will increase their browsing time, which actually in itself is a threat. Life narrative, which is really important to the cyber threat. Things like financial concerns, previous criminal records, personal history and ideology can be a huge contributing factor to someone becoming an insider threat. And then lastly, psychological factors, enduring traits of personality, dynamic states and the like. The important thing to note here is that in all the research conducted to date, there are things called tippers or concerning behaviours which the individual will make, which if the organisation was monitoring and managing correctly, they could possibly help to avert the threat. These tippers are often treated in isolation, but if a wider view was taken, they can be seen as concerning behaviours, and patterns can emerge, which can potentially mean someone is heading towards becoming an insider threat. Disgruntlement has been shown to be a most significant reason behind malicious insider threat, but at the moment, do not underestimate the uncertainty caused by the pandemic, and that being a huge issue in, as I said, a prediction that there will be an increase in this malicious insider threat over the coming years. Next slide. So I mentioned earlier what we call the critical path to insider threat, and that's shown by this model. Typically, it means that an individual will have some sort of path towards committing an action. And it starts with personal predispositions. It's then increased by a stressor or stressors, which then leads to concerning behaviours within the workplace. And then problematic organisational responses then lead that individual down a path to inevitably conduct a hostile act. And whilst it's a very general model, the vast majority of insider case reviews fit into it, and thus we can use it as a handrail to predict the threat, if you like. Take, for example, an engineer working as an R&D engineer in a large automotive company in what was deemed as a sensitive position, generating intellectual property for the cutting edge of technology for this company. They'd passed all pre-employment checks and vetting for the post, and in the first 3 months of employment, they integrated well into the team. Shortly afterwards, though, a manager found them using personal email on a work machine, and they gave an informal warning as it's against the acceptable use policy. The individual defended themselves with no apology, said it was urgent, and in the future, they'll simply use their phone. In the next 3 months, they started using their phone more and more at work, and it was beginning to become noticed and resented by colleagues. Boss decided to intervene and create a formal verbal warning for his actions. And shortly after, that engineer became more introverted at work, became less social. Colleagues kind of started to be a little bit concerned, but presumed because the warning became fairly well known that it was due to that. About 6 months later, the boss once again noticed the individual using email at work and decided to involve HR this time and create a formal written warning. The next day or the day after it was given to him, he handed in his notice. And when IT came around to disabling their account, they decided that it would be a good idea to review the activity of that individual on the system. And it was only when they did that they discovered he'd been using corporate he'd been exfilling corporate files through his personal email, so emailing out corporate data to himself. The company clearly got concerned about that and decided to proceed with a legal case against them. During that case, it was discovered that the individual had a addictive personality, or read personal predisposition on the chart. They got into bad levels of debt through online gambling, read stressor. They became introverted, and started to break soft rules regarding mobile phones acceptable use, read concerning behaviours. And the warnings at work, which were somewhat mishandled, became problematic organisational responses. And this led to the individual resenting the organisation and thus figuring that he could exfil or take off the system intellectual property of the organisation to sell it for financial gain, to attempt to fix his monetary problems caused by his gambling addiction. So how do we mitigate this sort of insider threat? Next slide. Well, with various controls available to us, and I'm conscious of time here as well. For people, we have the ability to conduct vetting, pre-employment employment checks. In government, we use them extensively. This could be an in-depth employment reference where instead of asking someone to fill out, you actually talk to them. You gain a social relationship with a previous employee or someone who knows that individual well, and you can pick up a lot through that. We can use CRB checking, psychometric testing to add certain other elements to it. And this can all be done prior employment to build up a really good picture of that individual before they join the organisation. During employment, it's then critical that we monitor for stresses. We monitor for those stresses of that individual. We can do that through opinion surveys, appraisals, informal management meetings, and then that we address those stresses as best the organisation can before they lead to concerning behaviours. For processes, it's up to us to manage those or mitigate those problematic organisational responses. We need to review line managers' disposition for dealing with things in isolation, because actually if they're reported correctly to HR, you can start to build up that picture of that individual throughout their employment time, and then see problems before they start to emerge. And it's also about joining HR and technical teams. They often work independently, but actually technical teams have a lot of access to information which can feed HR teams and again build up that better picture. Technology-wise, people process technology, the triad as we call it. Technology-wise, there's a lot of emerging technologies that can really help with this sort of thing. User and entity behavior analytics, UEBA, is a huge newcomer, but it's gaining traction. And this is automated analytics log monitoring, if you like, that will look for patterns such as uncommon log-on times. Is this person logging on later and later at night? Are they accessing more and more data? If you twin this sort of technology with data loss prevention and network detection technologies, you can actually build up a powerful list of technical tippers that can then be passed or used by HR with other information, the social side, to then build that picture and act on it. It's clear through research that the best mitigation to insider threat is that combination of social and technical controls. So using a multidisciplinary team from HR, legal and IT brings both different perspectives to a potential individual or threat, and also can help avoid those problematic organisational responses before they're made. So looking for those stresses, trying to manage those, looking for concerning behaviours and managing those before you even get to what can be seen as problematic organisational responses. Next slide. So how do we bring that together? I know it's a bit wishy-washy, but ultimately it's through culture. Some of the most secure organisations on the planet have been exploited through insider threat, but it pales actually, those exploitations pale into comparison with what could have happened. And most of that is thwarted through the use of culture. I said at the beginning that people are one of the biggest cyber threats to your organization, but they're also your first and best line in defense. And by fostering an open security culture through corporate values, enhancing that with policy and process, teaching and empowering employees and fostering communications, building that open reporting environment, you'll involve the whole organization in this response to the insider threat and not just parts of it. Next slide. Just as a take home, to start to build that culture, we believe that cybersecurity starts at home. We work very closely with the NCSC, the National Cybersecurity Centre. We're an accredited body of theirs for risk assessment and risk management. And what we try and preach is that your staff are just as big a target at home as they are at work, and that particularly pertains to government employees, but it does in every other industry as well. By engendering good cybersecurity policies in them at home, you'll foster that same action at work. It's pointless in asking people to use good password management at work when at home they use the same password for everything. Great way of doing this, or starting to foster this cybersecurity at home message, is point your employees at the Cyber Aware program given by the NCSC. It's really good. It's increasing all the time in information, but it's just simple steps that will help build that pattern that they'll hopefully then bring into the workplace, and you'll start to counter that insider threat through culture. And that's it for me.
Thanks so much, Ali. Thanks for that. Really interesting stuff. We appreciate you taking the time today to come speak at this HR breakfast. And just to say to everybody, obviously appreciate that was a whistle-stop tour from Ali through his presentation on individual threats. If you do have any queries on the back of that, there's a contact email address on the screen there, and I'm sure that a lot of you may have some queries on that, or may want to follow up with Ali on a few points that that you think might be pertinent to your businesses. And then just finally to say thanks to Ali, but also to Sally and Claire for speaking today. Again, like I said, it's been a tight agenda and a little bit of a whistle-stop tour through our caseload updates and the information Sally gave on no jab, no job policies. So again, like I said earlier, a follow-up email will be coming out after this webinar closes in a moment's time, and that will have all the contact details on for today's speakers. And like I said earlier, also a survey as well that we'd appreciate if you could complete to tell us what you thought of today's session and whether there's any topics you would be interested in us covering in these sessions moving forward. As you know, or those who have been to a HR breakfast before will know, these are we run these breakfasts on a quarterly basis. The next one will be in June of this year. For those of you who've been with us a while, you'll know that we used to host these at the Kuits office. We haven't done that now for over 12 months. And as Ali mentioned, and Sally and Claire earlier, we're on a roadmap now out of the pandemic. When we'll be able to welcome you back to the Kuits office, we're not certain yet. But actually, I know some of you will be really keen to come back and have that networking element and come have some breakfast with us and a coffee. And sit and engage with us. And I know that some of you have really enjoyed the webinars and being able to watch these online from home. So at some point in the next few weeks, we will be coming out to you to ask how you would like to consume these breakfasts in the future, whether you would like to come back to the office or online, or whether we can have a hybrid of both. So just conscious of time that we've run over 11 o'clock. So just finally to say, thanks to everybody for attending today. I hope you found that really useful and engaging. And like I said, look out for the follow-up email, and the recording of this will be coming out as well. So look after yourselves, and I look forward to catching up soon. Thanks for attending.